Okay, why don't we go back on the record if the reporter's ready. So there were some documents that were provided to us. I'm going to allow our general counsel to describe those and put those in the record. And then I think what I'd like to do is go a little bit out of order, but see if there are any members of the public who wish to provide any comment, and then we'll close with the last round of questioning. Mr. Cole.
Yes, during the break, MetLife has provided us with 2 sets of documents which I want to have marked as exhibits and placed into the record of this proceeding. The first set of documents are 6 single-page letters in the time frame of 2003 to 2004 between MetLife and the California Controller's Office regarding certain aspects of SG of stock and placement of that stock into the controller's accounts after demutualization. I'd like to have that document, which the first page of which is a letter from ACS to Mellon Investors dated August 9th, 2004. I'd like to have that identified as Exhibit 2. And the second is a 4-page letter from MetLife to the New York Department of Insurance, also relating to demutualization issues. That letter is dated December 17th, 1999, and I'd like to have that marked as Exhibit 3.
And Mr. Cole, if I might note that in that packet of letters that you referred to as Exhibit number 2, there is a letter dated December 29, 2003 from the Controller's Office noting that on behalf of as agent for the state of the California, we reviewed the due diligence previously undertaken by Mellon Investor Services on behalf of MetLife, Inc. in the achievement of property associated with MetLife's demutualization. We believe that the due diligence was generally consistent with California unclaimed property law.
Right, I have it here. Okay, so let's see if there's any member of the public who would like to comment at this time. We have a microphone set up over here for that purpose, and if individuals would like to come forward, identify themselves, and share with the panel any comment they'd like to make, this would be the appropriate time for that.
We'll see if this works.
We can hear you, I think.
My name is Bonnie Burns. I represent California Health Advocates. We're a nonprofit advocacy group. And I thought I'd just bring some personal experience to this. I've been a consultant to consumer groups now for over 30 years. And in the time that I've been working with Medicare beneficiaries, the primary population that we serve and that I've served throughout my career, I've seen some of the results of people being sold what I would call low-value life insurance policies. These are policies that pay very small amounts, anywhere from $1,000 to $5,000. And in some cases, people were sold multiple policies, maybe 2 or 3 policies of $1,000 each, because of the sales activity of certain agents when they entered their home to sell them Medigap or later the Medicare Advantage programs. So often people buy these without even understanding what they have, and the reason that they're buying them primarily in those small amounts is because they want to be able to leave some money or for a family member, or that they want to pay for burial expenses. And those are the 2 primary reasons that they buy these types of policies. And rarely are people going out, trying to buy these. These are the products that they're very often sold. And so I had a client come to me fairly recently that I thought might illustrate some of the effect that this can have on families when claims don't get paid. This is a woman who had, she's in her 50s, and she had lost her husband in a horrible automobile accident on Highway 17. And they were in the process of losing their house through foreclosure, which happened not long after he died. She knew that he had a $1,000 policy somewhere, but she didn't know how to collect on that policy. Eventually, she got in touch with the company and had a number of different conversations by phone with the company that was demanding proof from her that she didn't have. A lot of her belongings were locked up in the house when she was evicted for non-payment of her mortgage. Eventually, she came to me through a mutual acquaintance, and because I don't do casework anymore, I called one of your deputies, and she was very quick to help this woman, to put her in contact with the right person, and within days, that $1,000 was paid. And she had been living in her car. She had no money to even pay for a hotel. And that $1,000 represented the only money that she had until she could get on to one of the public programs. So that $1,000 would be a small amount to a lot of people. To her, it was everything. And without intervention, it's hard to say whether she would have ever gotten that money paid. So I wanted to put just a little bit of a human face on that because I know this happens. We've had clients, and I have over the years, older people who've bought these smaller denomination life insurance policies, and either they forget that they have them or they put them into a safety deposit box, and when they die, often people don't even know these policies exist. And so I think that might be some of the policies you've been talking about today that belonged to people who lost track of them. Their family may not even know that they had them. And the people who bought them bought them with the intent to do something for their family, to either pay for the burial expenses or to help fund a grandchild's college education, or some purpose that they had in mind when they originally bought these policies. And older people, when they buy something like that, will pay for it long after it's of any value to them. I've seen people in the past pay more for these small policies than they would actually ever get out in benefits. And that's been an issue for me as an advocate over the years. Washington passed a law a long time ago that stopped that kind of behavior. You can't price a policy so that ultimately the person will pay more in premiums than they'd ever get back in benefits. California never adopted anything like that I know of. And in my work at the NAIC as a consumer representative, long before the consumer program began, this issue of life insurance policies has come up over the years, and there have been various models that have been adopted and changed over the years, but there still are a lot of loopholes in those models in terms of consumer protections. So one of the things I'd like to suggest to you are some of the things that we learned from the long-term care insurance that might actually be of benefit to some of the discussion that you're having today. And that's that if companies selling life insurance policies had to include a third-party notice as part of the application so that someone else knows not only that they have the policy, but would be notified if that person failed to pay premiums, or would be notified when there were any changes to the policy or to the company. If, for instance, if a block of business is sold off or a company is acquired by another company. A third-party notice could be very helpful, and if that were done as part of the application process, and it was required periodically after that, so that companies would be required to send the policyholder information that they could appoint a third party to receive notices about their policy. I think that might help alleviate some of what you've been talking about today. In the event that there was a third-party notice, somebody who was that third party, they should receive a copy of the schedule page so they know and will know in the future what that person owns, along with the contact information for the company. And that should be part of any documents that a third party would get. In listening to the company and to talking about when they do conclude that they are unable to contact somebody, you know, I was wondering when the company was saying that they conclude this after they've received 3 returned mailings, and I was wondering how long is that period of time between each of those mailings? Is it a month? Is it 6 months? Is it a year? How long does that take before that, before they conclude that the person is unreachable? A third-party notice would solve part of that problem if people designated one. And so I think the company should be required to, when they get returned mail from an address that's incorrect, that they should be required to make a personal contact or attempt to make a personal contact with whatever information that they have on hand, instead of waiting until that's happened 3 times. There have been incidences of companies mailing out things to people at the wrong address, not at the person's incorrect address, but a wrong address that somehow got into the company's records. I've had that happen with other products when people were canceled because their notice went to the wrong place. So I think there needs to be more contact with the person who's bought the policy, and that a third-party notice would go a long ways towards alleviating some of what we've been hearing about today.
Great.
And thank you for that.
Thank you very much. Any other members of the public who wish to comment at this time? On the point raised by Ms. Burns, is there any time period requirement between each of the 3 pieces of mail that becomes a triggering event if they're returned for purposes of deciding that a total control account is dormant?
Yeah, first of all, the situation you described was unfortunate, and one that we hope isn't indicative of the industry more general around the individual circumstance. The period between mailings varies by product. In many cases, it's once a month, but it can vary by product. And as always, we welcome suggestions on how to improve, and want to do our best to continue to do what makes sense for policyholders.
With regard to the total control accounts, though, where that 3 return pieces of mail is a triggering event, how frequently are mailings sent to beneficiaries who have funds in a total control account?
So for a total control account, if there is activity in the account, it's once a month. If there's no activity in the account, it's once a quarter.
Okay, very good. I want to go back to 1987, when it was testified earlier that MetLife first started using Deathmaster on annuities. And I'm wondering if one of the witnesses can share with us how the company organized for reporting purposes and administrative purposes the annuity side of its business and the life insurance side of its business. If someone can just sketch out what the org chart was generally for MetLife at that period of time with regard to those 2 lines of businesses, that would be helpful.
I can't do that. Not that I wouldn't. I don't have it
Okay.
on the top of my head. We can certainly follow up as best we can. I don't know if
Any of the other witnesses have any understanding? There was mention that in 2010 there was a change made in the corporate structure that permitted a more holistic approach to these issues. So I'm trying to figure out, what was that a change from?
Sure.
Let me ask that question.
Yeah, so we can talk about how we were organized before 2009 and after. But
Yeah,
I
that
can't go
would be
back to
great.
87. So prior to 2009, we were managed in 3 operating units. We had a institutional business, which was essentially group, both insurance and pension, corporate benefit funding products. Then we had an individual business, which was individual life and annuities, and an auto and home business. In 2009, those were consolidated to form one holistic U.S. business.
Then prior to 2009, what, if any, mechanisms were there to coordinate information or decision-making across the three separate organizational structures that that existed prior to 2009?
I mean, I guess there was a combination of formal and informal procedures that were used to run the company. I think bringing it together as one U.S. business enabled us to be more streamlined across our business.
With regard to the utilization of DeathMaster in particular, were there any mechanisms prior to 2009 to share information from one element of the operating structure with the other elements of the operating structure as it related to DeathMaster?
Is this around how decisions to use DeathMaster?
Yes.
Yeah. Not that I'm aware of.
Okay. And then with regard to actual determinations made with the utilization of DeathMaster, were there any mechanisms to share information across the three operating arms prior to 2009?
Yeah, there were different means, some more formalized, some less formalized, around sharing information. Certainly we talked to the 2007 match, which I think is indicative of taking in a whole lot of death information and then using that at that point for our individual life business.
And Commissioner, we also spoke about the process that we have in place, which you now have a copy of the procedure around relative to individual annuities.
Do you know whether from 1987 to the present, MetLife retained any consultants to determine whether MetLife was properly internally coordinating the use of DeathMaster?
I do not know.
Okay. Any of the other witnesses have any knowledge?
Not that I'm aware of.
I have no knowledge of that.
All right. And then do you know whether MetLife's board ever discussed whether MetLife was coordinating the utilization of DeathMaster across its annuities and life insurance sides of its business?
Do not know.
Neither do I.
I don't know.
All right. And are you aware of any discussions on the part of MetLife executives since 1987 with respect to the utilization of DeathMaster between the annuities and life insurance sides of the business?
Other than what we testified earlier, which was around the formation of our 2010 holistic decision, I'm not aware of other types of discussions that cross lines.
Okay. Any of the other witnesses have any information on that question?
My understanding is the same as Mr. Katz's.
Okay.
That's right.
Stallman? All
Yes.
right. Okay. Does MetLife currently have any policies in place, corporate policies in place, as opposed to life insurance policies in place? Does MetLife have any corporate policies in place that govern the retention of documents held by the company?
I believe we do, yes.
Can you describe in general terms what those document retention policies are currently?
I cannot.
Any of the other witnesses have any information on those?
I know that we have a formal program, but I cannot quote to you the specifics of what it actually requires.
Mr. Solomon, do you have any
No,
understanding?
I would also add that we have a very robust document retention process and training around that across our company, but those practices vary, I think, across the company, but based upon the basis of each of the businesses. State law.
Are you aware? Are any witnesses aware of any occasion when MetLife has purged data from its administrative systems?
We're aware of when we purge data from our admin systems.
Are you aware of any occasions in which MetLife has purged data from its administrative systems?
I'm not. I'm trying to think of a circumstance where we would. So I'm going to say I'm not aware of any.
All right. Any of the other witnesses?
Not that I'm aware of.
I'm not aware of any.
All right. And are you aware of any policies that MetLife has with regard to purging data from its administrative systems?
I would assume in our document retention program it covers that, but I don't have that in front of me.
Any other witnesses have any understanding of what the policies might be with regard to the purge of data?
No.
I don't have any personal knowledge of
Is there any procedure for archiving records or information that have been maintained in the course of administering either annuities or life insurance policies for customers of MetLife?
I do not know. There very well may be, but I do not know.
Okay. Any of the other witnesses have any understanding of what the company's archiving policies might be with respect to policyholder information?
I don't know the specifics of
Well,
that.
and we can, well, keep going. I mean, this is, we just don't have this information.
Okay, that's fine. Mr. Solomon, do you have any?
Are you making a distinction between document retention and archiving?
Yes.
Not that we're.
Okay. Now that, do you believe such policies exist, though, with regard to
Yeah,
document retention and/or archiving?
Yeah, we do have a robust document retention policy. As Mr. Solomon testified, we have training on that. We just don't have it at the tip of our fingertips right now.
Okay. With regard to policies, insurance policies that have lapsed, do you continue to retain records associated with those insurance policies?
I believe we do.
And has that always been MetLife's policy and practice?
I probably can't attest to always, but going fairly far back and indicated by the match that we did, we matched against a substantive amount of lapsed policies.
So when you ran the 2007 sweep, I think you testified that the earliest policy owner for which you had a match was 1974, if I remember correctly.
I think I said it, and it was the date of death was 78, I believe.
Date of death was 78. What would account for not coming across policies with earlier dates of death?
I think it would be to the point that Todd made around the fact that Social Security numbers were not required on life insurance policies that early on. So the there may have been limitations in the data, specifically as it regards a match against the Social Security death master file on older policies where Social Security numbers are not part of the administrative data.
I also think Social Security only began capturing deaths on that file, I'm going to say late 60s, early 70s, something like that. We can get you. It's probably not our date, but it's...
So it's probably a combination of the two.
When did MetLife begin requiring a Social Security number on the life insurance or annuities?
In the early 80s for life insurance.
And annuities?
I believe it was with respect to certain tax law changes that were made in the mid-'80s.
Mid-80s, was it?
Yeah.
So does that answer apply to both life insurance policies and annuities, or just life insurance policies?
It probably would have been earlier than life insurance for annuities, but I'm not aware of the specific date.
Okay, it would have been earlier for life insurance than annuities, but not sure the particular date. Is that right?
The other way around.
Oh,
Earlier
okay.
for annuities.
Earlier for annuities.
All right. Earlier than 1987?
I just don't have the information, but we can let you know, certainly.
Okay, we would like to follow up on that when you can provide us that information. Going back to the Death Master file itself, has MetLife customized the Death Master file in any way for its own use?
So what we've done is taken the Death Master file and combined it with other systems where we have notice of death and used both of those sources to do the matches.
What are the other systems?
I don't have a complete list of what all those systems are. I don't know.
Can you describe any of them?
Certainly, for I know for certain that the deaths reported under the group annuity program,
Say again, I'm sorry.
any deaths reported under group annuities would be part of that file as well.
Okay, so it would be Death Master plus
Anything reported into our group
reported
annuity.
by, I guess, customers with regard to...
or other sources.
or other sources with regard to deaths of annuitants.
And it could be for other lines too. I mean, this is probably one. I think what you're getting at is what's the full content of the file in addition to the death match that we used in 07? Is that where you want to go?
Well, we can start with 07. I mean, when you... I don't know if there are any other periods of time which you may have augmented or customized Death Master, but let's start with 07. I mean, I think you testified that you coupled it with some other databases or systems. You weren't sure exactly which
Right.
ones completely, but of the ones you can recall, what are they?
Yeah, I don't know. I can testify to what I think. I think it was some of our annuity and our life systems. I'd rather get you as a follow-up in writing exactly what the components of that was.
And when you say annuity and life systems, what do you mean specifically?
Claims of deaths and/or death notices on those systems.
Were
So
those?
I'm hypothesizing here, so I'd prefer to just get you the exact.
No, that's fine. But as to that, then, were they used to augment DeathMaster, or were they used as a filter to screen out matches that were made on DeathMaster?
Oh, I believe to augment.
Okay. And are there any other databases that MetLife utilized in 2007 other than DeathMaster, claims information on the annuity side, claims information on the life insurance side, any other
For
database?
the purposes of the match that we did?
Yes.
So let us respond as a follow-up. We'll get you a comprehensive list of everything that was in there.
Okay. And then moving forward from 2007, in addition to those systems that you've already testified to or database you've testified to, any other databases you've turned to for information as you're using DeathMaster to either augment or filter DeathMaster?
So for our prospective approach, what we plan
Yes.
to use the 2010 and beyond, do you want to talk about that?
Yeah, no, for the prospective approach, we would not be filtering any data out of the Social Security Death Master. It is our intent, though, to augment the file with deaths reported anywhere in the U.S. business into that single file, so that if a death had not been reported to the Social Security Administration but had otherwise been reported to us, we would have put that into the data. We intend to put that into the database so as to share that information across
Across the company?
Yes.
All right. We talked a little bit earlier about the group life book of business of the company, and I'm wondering if you could share with us the total value of the group life book of business that's in force currently.
The amount of insurance in force?
Yes.
Ooh, it's a big number.
Yeah.
Do you know it?
I believe on a direct basis, 2.8 trillion.
Okay. And when you say direct basis, can you explain what the
To the extent that there's
adjective
any
direct means there?
any reinsurance.
Say again?
Any ceded reinsurance, before any ceded or accepted reinsurance.
Before ceded reinsurance. Okay. Have you used DeathMaster for purposes of determining if individuals have died who are eligible, whose beneficiaries are eligible under a group life policy?
So we touched on this a little bit earlier, that we have not. However, there have been some limited instances where group customers have done that on their own and presented us with information.
And what, of the $2.8 trillion of in-force policies that represent the value of the group life book of business, what value would you place on those customers who have used DeathMaster themselves in the aggregate, if you understand what I'm saying? What,
As a percent of the total?
either as a percentage of the 2.8 or an absolute value of the 2.8 trillion?
I think it's relatively small.
Yes, de minimis
Yeah.
relative to that.
De minimis.
I would think so, yeah.
Okay. How do you handle group life policy claims? What's the process that you go through for that?
Sure. So the employer generally is the one that submits a claim to us. They may take on the role of gathering all the information that would enable us to pay the claim and submitting it to us. They may send us partial information, and we work with the beneficiary ultimately to complete the information. And then it's a process similar to what we've described previously.
Okay. If actually strike that. Do you require that the group life customer provide you with a death certificate in order to perfect the claim?
Generally, we do, yes.
Okay. If you don't receive a death certificate, what do you do with that particular insured's policy?
So this is where the group business gets a little bit tricky, because by nature, we have different arrangements in place with different customers for the purposes of claim processing. So I can't give you a, here's what we do and don't do in that context. We tend to put forth best efforts to secure that information, because typically if an employer is providing a death, the validity of that death is usually pretty clear. However, there are circumstances where they've told us about a death, and for example, it's in a contestability period, or it's a situation where maybe it's a homicide, and there's other situations where the death benefit wouldn't be paid. We go through a pretty rigorous approach. So, but the procedures can vary by customer.
But in most, if not all cases, you require a death certificate to perfect the claim.
I believe so. I believe, and I don't have this number handy, that there is a threshold on some cases that below certain levels we may not. And I don't know if
I
Sandra
don't
has
have
that.
any information on specific cases.
And there are situations that we'll make a decision to waive the requirement. So the examples I talked about earlier, both we had big group exposures, both around 9/11 and the Massey Energy unfortunate situation. So while that is our standard procedure, we will make exceptions when we think it makes sense.
In a circumstance where a group life policy owner reports a death but does not provide a death certificate, what happens to the claim?
Generally speaking, we would put forth best efforts to work with the beneficiary to help them perfect the claim. In some cases, we would reach out and try to get death certificates. I don't have all the specific details on the group life. We can certainly follow up in more depth for you.
Are there any circumstances under which you close the claim without paying it because you don't get a death certificate?
I'm not sure.
Okay. Are you planning to run Deathmaster against the group life book of business as a part of your 2010 decision or not?
But we are for those cases where we have the records.
And remind me again, what percentage of the book of business are those for which you have the records?
Yeah, we don't have the number yet.
No, but it's a minority of the business.
All right.
It's a small piece of the business.
When will you be running Deathmaster against this small portion of the group life book of business?
It's scheduled to be completed by June 30th.
Of this calendar year?
That's correct, of 2011.
And how will you apply Deathmaster to that particular book of business? Will you be applying it any differently than what you've testified to? Is your intent with regard to the individual?
Our intent is to use it in a manner substantially similar to what we do on the individual side.
Any differences that you're aware of?
Other than some nuances which I may not be aware, no, our intent is to use basically the same protocols.
I want to be a little bit careful in the context of our discussion around group, in that some of what you're asking us to describe is prospective in nature, and we haven't fully communicated our intents completely to our group customers. So we prefer to do that than use this forum as a way to do that.
But again, your intention is to limit the utilization of Deathmaster to those for whom you have administratively information about the individual members of that group for whom the group life insurance is being provided. Is that correct?
That is correct.
Okay, and that's a small portion of the overall group book of business.
Yes, correct.
All right. And there are no plans to use Deathmaster with regard to the rest of that group book of business, are there?
Not at the current time. We don't have the records to actually practically make the match.
Okay. Let me see if either the Florida or the Minnesota departments have any additional questions. We'll start with Minnesota.
Back to this group business and not having the information, is that you don't have the name and the social security number for the employee?
That's right, yes.
How do you verify from time to time that the employer is paying or emitting the correct premium for the risk you've got?
Generally, group contracts are experience rated, so that we're doing an annual review of the experience that emerges under the program, and at that time, a premium reconciliation is generally done in the aggregate. Look for number of lives and total face amount of insurance in force times the premium rates, but there's no listing life by life under group insurance contracts.
We should just make some small clarification. That's for oh, that's right. You're absolutely right, yeah. I was going to say, other than the business where we do have the records, but we've already talked about it a little bit.
So how do you verify the number of lives versus the claims experience? That's what I'm...
The customer reports the lives in the aggregate to us in bulk.
And you don't do
and then
any
we do a premium
independent corroboration of that?
At the time of the annual review of experience. They're all group insurance contracts are generally experience rated. The underwriter would be looking at the rates applicable to the case times the total number of lives and the total face amount of insurance in force, and would do a premium reconciliation.
Then system deaths, you're going to augment Death Master by deaths that you've had reported in your other business. That goes back to some prior line of questioning. Prior to more recent times, your company is not, when they have an individual life claim, they don't check group and annuity and see if they've got business anywhere else?
There definitely is information sharing around the organization. It's become far more formal in recent years.
Now, what I asked, just to clarify, prior to, say, 2009, would the individual life claim reviewer pull up the group systems and the annuity systems and see if there's any other business anywhere else?
So prior to 2009, the policies in place were a little bit more informal by department. The intent where we could was to share information, but as you correctly laid out, in recent years, we've improved these processes, and Mr. Solomon gave a good example of that in the annuity business.
So the answer is no?
No, I think there were more informal processes to share information prior to that.
Well, could an individual life examiner actually pull up the group business and the annuity business and look at it?
Since the group would not have had, since we didn't have the data, there would have been no system to look up life by life data on.
So if you got a group claim on an individual, could the group person pull up the individual annuity business, the individual life business, and look to see if they had other claims out there?
So the system access, and some of this is, I talked about how the organization has changed over the years to get better in that place. We're not aware of any situations where there was a death claim over here and boy, over here there wasn't, and we didn't handle it in the right way.
Well, the reason I ask is because it wouldn't seem to make any sense to augment Death Master with these other claims when you're going to then apply them to other lines of business in the company. Do you follow me? Unless you think this department over here didn't communicate that. Because otherwise, when this person died in the group or life business, there should have been already in some circle back where they figure out whether that person had other business with you.
Yeah, so to the extent our information sharing proves insufficient, creating an overall company view of deaths we think is a good fail-safe to apply across our business, and to make sure if it didn't work through regular information sharing, it wasn't on the SSDI, we certainly would then capture it in the systematic approach.
Then individual life business, do you have a total in force for that too?
Do you have that handy?
Yes. For the industrial block, which we talked about, it was about approximately 1.5 million policies, which represented about 2.4 billion in force. And on the other individual, other than industrial, more than 6 million policies and about $1 trillion in force.
And then for individual and group annuities, do you have for fixed and variable, do you have assets under management for fixed business and variable business? Assets under management?
I don't have the number. You probably have the individual number handy.
Well, you're exactly right. That's how we do measure our in-force is by assets under management that are held both in our general account and for our variable products in separate accounts. But I can get you that information. I have it handy.
All right, but that's what would be out there as sort of the counterpart to in-force business for life, correct?
Well, we would have individual records on each of those contracts that we would use for the purposes of administering those contracts. But one way that we measure the growth of our business or the size of our business, the corollary to in-force, life insurance in-force, is by assets under management.
Right.
So we'd be happy to provide you with a detailed breakdown of assets under management.
Can I ask another question?
Absolutely.
Payout options, you said when in these little, when you're running Deathmaster against your annuities during payout, you suspend when you have a Deathmaster sweep that indicates the person may have died. How does that match up? That's a yes, I take?
Yes.
How does that match up with the annuitization options the person has selected? I know there's period certains, there's for life, there's joint survivor, all sorts of different terms they use for how a person elects to get their annuitization payout.
I think what we testified was that the match is the first part of an investigation, and in fact, you may have a contingent beneficiary who is eligible for payments at that time. There may be a death benefit payable at that time. As you rightly point out, there may have been an annuity certain, and so the beneficiary might be eligible for a commuted value in that particular instance. So yes, you're right. That's the reason for a suspension, and then someone has to go in and look at exactly what benefits are due at that point in time.
Thank you.
Let me answer your question on the individual annuity side of the business. If there's an annuity that's in payout status, once that individual dies, under some of our contracts, that's when our obligations end. There may be a period certain benefit, as Mr. Cassandra mentioned. On the individual side, on the pay-in side of our business, there are 7 options, and I can go through those if that'd be helpful, including a lump sum. You can also defer the contract up to 5 years. There are cases where you can let the spouse, in effect, step into the shoes of the original contract owner and continue those benefits. There's an income payment option where the beneficiary can receive those payments in installments. There is you can roll over the death benefit to another carrier through a tax-free exchange. You can actually disclaim the benefit because you may want another beneficiary or estate to receive the benefits. Those are some examples.
Thank you.
Florida?
I don't have any other questions. I do have one comment, and that is just to thank the Commissioner and the Controller for having us and for having this hearing. And we appreciate your efforts and appreciate you including Florida. And thank the company for your cooperation and for coming to this hearing as well as the one in Florida. So I do appreciate it.
Thank you very much. So before we close, there are just a couple of other questions that occurred to me. Let me ask, though, if the Controller's Office has any additional questions first.
Thank you.
Is Deathmaster or has Deathmaster been used to ascertain whether a claim is made inappropriately or fraudulently? Is it being used in any way to verify claims made?
There are some data field verification work that I know it's used for. I wouldn't consider it as a tool in the way that you're just. Is there an example that you're thinking of?
Well, we've explored those uses by the company or non-uses by the company of Deathmaster for purposes of deciding when people should keep paying or be paid. But it occurred to me to wonder, when someone submits a claim form for benefits, is Deathmaster used to verify if in fact a claim is warranted or justifiable.
Yeah, so while I can't give you too many specifics, certainly there's an anti-fraud component that I'd articulate for it. You know, if you think about it, it's another resource that we could use. I wouldn't say we use it consistently in that context, but if you think about, probably the best example might be in the payout annuity piece, that, look, if we didn't apply it and nobody told us that that individual was dead, there's a potential that we could pay those payments for a long time when they really weren't due. And that's probably a good example of where the fraud usage might come in. And in some cases it's fraud, in some cases it's, the person who's getting those funds just may not know that they're not entitled to them, especially if it's a direct deposit or something like that. So it avoids that situation, certainly.
Right. No,
Commissioner, could I add another point
Yes.
that I think might not be obvious? So it's our understanding right now that the rigor with which an individual's name and Social Security number can get entered onto the Social Security Death Master file is not very rigorous, and that the Social Security Administration does not. It's our understanding that they don't require any proof. Merely a telephone call, in fact, can get someone's name and Social Security number entered onto the Death Master file. And, it has occurred to us in the realm of unintended consequences that today there's no incentive for anyone to put information onto the Social Security Death Master file in a fraudulent fashion, in the way it's generally used across the industry. I think it would be good for the regulators and for the industry to think about unintended consequences which would have just merely a listing on the Social Security Death Master be deemed a absolute proof of death. I think before anyone would think about that, should understand very clearly the rigor with which Social Security Administration screens the entry of deaths onto that file, because one could see, and this is a hypothetical situation, but one could certainly see the potential for someone to report a death into the Social Security Administration solely for the purposes of attempting to collect on a life insurance benefit. I don't think that's the case now, but it could potentially be an unintended consequence of a change in the very historical process for the way life insurance benefits are claimed.
I just say, though, that the information available to us, based on testimony provided by the Social Security Administration to Congress, is that there's a high degree of certitude with regard to the names on the list. So that's directly at odds with what you've just said.
No. I think that. Let me just clarify. I think that's true today, and given that the traditional uses of the database today, I'm saying should that process change significantly, the uses change far beyond what the Social Security Administration's intent was originally when it was first used, there might be the opportunity for unintended consequences, and I think it's just good if we spent a little time to think about that as we go forward.
Okay, but that's different than the question I was asking, which is whether it's being used for other than making determinations that annuity payments shouldn't be paid, which was a concrete example. But are there other ways in which Death Master is being used to decide that a payment shouldn't be made? Like, it sounds like the answer is no, but you're not using it.
Not that we're aware of, no.
Okay.
So, yeah.
I've been trying to
Right,
trying to think.
so you're not
this
using it
through.
routinely when every claim that comes in the door. You're not doing a match against Death Master to see whether or not the name is there or not. I mean, you're not using it in that context. Okay.
Not for life insurance, certainly.
All right. And then going back to the industrial policies, have your company's actuaries done any estimation of the number of industrial policies written by the company? Any estimation of the number of industrial policies for whom the policyholder is probably dead?
I'm not aware of any such study.
I don't have any knowledge of any such study.
All right. Sir?
I'm not involved in that side of the business. I couldn't tell you.
Okay, but you have no knowledge
I'm
of?
not aware of anything.
All right. And what about with regard to
I should just make an important point about those industrial policies.
Go
If I didn't
ahead.
make it earlier, I'll make it quickly. That those policies are still all performing. So those are still getting dividends every year.
You made that point before. They're getting dividends as a result of those policy owners' prior interests in the mutual company, and that interest being converted to a stock ownership interest in some form?
No, I should, let me give you the context of where I'm going with this. If the discussion went along the lines of, and you haven't said this, but you know what, you've lost these policyholders, why don't you go ahead and just escheat some amount to the state, because you believe some of them are dead. And we have no reason to escheat in that case, and we want to make sure that as long as those policies are active on the books, they are growing in value. As part of that closed block, they are growing. So some of those policies today, they may have been issued with a $1,000 face amount. They may have a $2,000 or $3,000 face amount today. So I'm not suggesting that you were saying that's what we should do here. But ultimately, when those policies are either paid out, I'm talking about the industrial block now, or escheated to the state, which all of them will be, it will be at the value associated with, the growth at that time.
Just to clarify, I think what Mr. Katz meant is they're getting policy dividends, not stock dividends.
Right.
Okay, but before we go to Minnesota, though, let me. You testified earlier that with regard to those policies, that at some point they reach, I think the term of art was, and they become endowed, or they reached a point of superannuation. Can you explain those two terms for us?
Yes, superannuation is when the policy that hasn't been matured by death, in other words, a death hasn't occurred, it reaches the end of the mortality table that's used to value those policies. And so for the industrial block, that's age 99.
Okay.
So upon reaching age 99, or earlier, depending on the policy form, and when policies, if they reach the end of the mortality table for which they are used for valuing them, the money would be escheatable to the state at that point in time.
We would attempt to locate a beneficiary and a policyholder, and if we couldn't, we would escheat.
How long do you take to locate before you decide to escheat policies that have reached that point?
I think the dormancy period would begin on the date of superannuation, so it's a 3-year period in California.
So are there any industrial policies that have reached that point of superannuation?
I don't know. I
would venture to say yes, there is, and to the extent that they've filled the dormancy period, we've escheated them.
Okay, so you're accounting for those then?
Yes, in fact, 1 month, as I understand it, 1 month before the policy would otherwise reach the superannuation age, a letter is sent to the last address of record on those policies to attempt to reach out to the beneficiary at that point in time. And then I believe if we don't get a response to that, it's entered into the unclaimed fund system.
The note I made when you testified previously on this point was you said it reached an endowment or superannuation. Did I understand?
An endowment's a different type of policy. It's not a life insurance.
Can you explain that term?
An endowment is a policy that grows to its maturity value and then pays out that maturity value.
Okay.
So, and I just want to make sure it's clear that these benefits can be escheated, as I understand it, without there being a death. When you hit that period, whether the person is dead or alive, that money goes through the unclaimed property process if we can't locate the beneficiary.
Okay. I think Mr. Hanson had a question.
When was the demutualization completed? What was the end date?
When, I mean,
Just approximately, you know, which
it was
year?
in 2000.
Year 2000. So you've got 800,000 lost industrial policyholders. Probably haven't found any of them in the last 10 years.
I don't know the answer to that.
And you say they're performing, and what you're saying is you didn't mail a check to that person, here's your dividend for this year. You've just accredited it to their policy value.
They get additional
So
insurance.
you may still have 800,000 or more lost industrial policyholders today.
But we may.
But you had no contact
one
with-
would say more likely than not the number would have gone down as claims were paid or policies were superannuated. But the issue of lost policyholders is an industry issue, and you know we welcome discussion on how to improve upon that. We think the death index is a good usage, but the problem is it's not perfect because many of these policies don't have SSI.
I just wanted to get to that. Performing isn't that this person was getting a regular check coming to them. It's just being credited to their account. And you may not have any better information today about those 800,000 than you did 10, 11 years ago now.
That's correct. I was attempting to juxtapose against the hypothesis that says that money is just sitting there at MetLife and making sure that you understood that the policies were being credited dividends. That's really all I was trying to do.
Okay, and then I guess finally, I appreciate what you said earlier about what the company is guided by with regard to its efforts in this area. But is it not the case that to the extent that beneficiaries are not paid or money is not escheated to the state of California, the company benefits financially?
I don't think, while I understand your comment, I don't think you can say that with absolute certainty, because on the annuity side, when we use the benefit, we're using it to avoid durational payout errors, right? Which is to pay an amount other than that promised under the
Right, but I wasn't talking about Deathmaster specifically. I was just saying that in general, when benefits are not paid by the company or benefits are not escheated to the state, the longer it takes to do either of those two things, the greater the financial benefit to MetLife. True or false?
Again, I'm not sure I can agree with that. Because
Why not?
Because on death proceeds, we pay interest on death proceeds from, at least in the state of California, from the date of death. So I think there are factors that go both ways in that question. So I appreciate your position, and you think intuitively that's the answer. I can't say that with absolute certainty.
So other than the
And-
interest
and-
on death proceeds, though, I mean, with regard to interest paid vis-a-vis escheatment, that doesn't kick in until liability accrues, and liability may or may not accrue until well after the death of the individual, based on what you've testified to earlier. So other than the interest payment on the death benefits, it just seems to me that the longer it takes to pay a benefit or the longer it takes to sheet the funds, the better off is the company.
I think there's two other aspects I'd bring into it. One is the cost associated with managing the blocks on our book at any given point in time. And I wouldn't presume that the premium allowable for those expenses cover those expenses. In some of the blocks, it's not close. But the other factor, which is probably most important, is we're in a business where your reputation matters. And so we're having a conversation today about, as you are, I think, hypothesizing what I believe would be de minimis in the context of the overall size and earnings of this company. And on the other side of the equation is the importance of us making sure we're delivering on our promises to our commitments so that we build the right level of trust with our customers. And that's very important to us. And I can't place a value on it, but I can tell you it's large.
I appreciate that, but I also hope you appreciate the concerns of the controller of the state of California and the insurance commissioner of the state of California and the other insurance regulators and unclaimed property agencies with regard to the extent to which life insurance companies have availed themselves of a readily available tool to determine whether or not benefits can and should be paid, and whether funds should be escheated to the state. And we appreciate your participation in the hearing today. We will look forward to the additional information that you've indicated you can provide us upon further investigation. And we will reserve our ability to invite you to come back to testify further on questions that couldn't be answered, but we appreciate your participation in the hearing today. Thank you very much.
Thank you.
If there aren't any other questions of the members of the panel, that will conclude our hearing. And I want to thank the members of the public who attended, and as well I want to thank the representatives of MetLife for attending too.
Thank you.
Thank you.